Hello, everyone, and welcome to another episode of Trial by Podcast. So I'm joined here today with Andrea and Antara, and we're delving into the topic today of Lattouf versus the ABC. So a landmark decision in the Fair Work Commission, where we saw kind of the court make a decision on the boundaries between political expression and brands and their reputation and the kind of balance between those things. So we're going to get into it today, and Antara will kick us off.
All right, so we're firstly just going to brief about the case and what it's about. So did you want to set the scene, Andrew?
Yeah. So in December 2023, the journalist Antoinette Lattouf took legal action against the ABC after she was unexpectedly removed from her casual role. And this was just 3 days into a supposed 5-day stint.
Yeah, and so she shared a Human Rights Watch video on her Instagram that basically accused the Israeli government of using starvation as a weapon of war in Gaza. And she captioned that post, HRW is reporting starvation as a tool of war.
Yeah, and then less than an hour later, she was pulled off air, and ABC alleges that this post was controversial and potentially breached their social media policies. But the key thing is that policies that she was alleged to have breached were not identified, and she wasn't given the opportunity to respond to these allegations.
Yeah, exactly. And the main part of this case was that Lattouf arguing that her dismissal was politically and racially motivated. So that looks into her claiming that the ABC acted under pressure from pro-Israeli lobby groups and that its actions violated the Fair Work Act. So that basically protects dismissal based on political opinion and race contained in Section 772(1). And now we're looking into basically with the court if the ABC rejected all these claims.
Yeah, and so the court found the decision in Lattouf's favour. They said that the ABC did in fact breach the Fair Work Act by dismissing her, partly because of her political views regarding Gaza. However, the court did not agree that she was also dismissed because of her race or ethnicity. It ruled that ABC had breached their obligations under its enterprise agreement to undergo procedural fairness before they take disciplinary action. And yeah, so ultimately the court ordered that the ABC pays Ms. Lattouf $70,000 as compensation for non-eco from the unlawful termination.
Yeah, so now that we've gone through the actual case, I guess the main question is, what does the law say about political expression? I think this case really does shine a light on something that we don't often talk about in Australia, and that's basically how are we protected in terms of our political views in the workplace? So what do you think?
Yeah, so I think, as you guys mentioned, there's the express protection in the Act for expressing your political opinions and your right to do so, but not necessarily if it crosses a line of what your employer deems is okay. So I think that case is really interesting because now we actually have seen it come to life with employers and employees going at each other for expressing a political opinion and where the court stands with that.
Yeah, and when it comes to Australia, we don't exactly have an explicit right to freedom of speech in the Constitution like, America does. Mm-hmm. So, but we do have something that is called the implied freedom of political communication.
Yeah, and this idea comes from the High Court Lange and ABC case, where the court said political communication is essential for a functioning democracy. So we have an implied right to it, but it's not unlimited.
Yeah, and the test looks into two key questions. Does that law restrict political communication? And if it does, is that restriction appropriate for maintaining a responsible government?
Right. So basically, in the implied freedom of protection, you're looking at what is the limit of that, is what we're looking at.
Yeah. And I think another important note is that in New South Wales, we don't have state laws that protect political opinion with anti-discrimination laws. So the Fair Work Act actually just becomes a key piece of legislation for all of this. Also in the Lang case, the High Court found that since Australia is a representative democracy, this system can't really function unless people are free to express their political opinions, which I think is really interesting because that's where it kind of, leads to these cases happening where there's that murky line. Australia does have protection of political communication, but because it's not direct and explicit, it leads to a lot of cases like this where, people can make claims for defamation for political communication. Mm-hmm. So I think that's really interesting.
Yeah, so And we have seen cases before, so I've actually pulled a couple. So in Carey versus the Cairns Regional Council, Mr. Carey was dismissed from his employment in council due to his relationship with political figures with views not in line with the council's. Mr. Carey brought a claim on the basis that his termination was due to his affiliation with these people and with a differing political opinion. The employer claimed that this was not the reason for termination, but rather poor performance. And the court actually rejected this argument, stating that there was evidence actually of a direct discrimination on the basis of political belief. But in saying that, that's a case where the court is deciding in the favor of the employee.
Yep.
But there are also cases where the court is favored on the side of the employer. So in Quirk versus it's a long one, so you have to bear with me. Construction, Forestry, Maritime, Mining and Energy Union. The applicants, Mr. Quirk and Mr. Miller, were elected officials. They expressed an opinion on the ABC morning program where they accused their employer, the defendant, of corruption. They made similar statements to the Sydney Morning Herald, and they actually ended up publishing their remarks. So the employees were guilty of gross misbehaviour within the meaning of the employer's rules, and they were removed from office and their employment was terminated. So they made an application to the Fair Work Commission stating that the employer had contravened Section 351 of the Fair Work Act for adverse action against them for expressing a political opinion. They also stated that the employer had contravened Section 340 by taking adverse action against them because they had exercised a workplace right. The court dismissed the application on the grounds that the employer had not dismissed the applicant specifically due to their political opinion, but rather their disloyalty to the company for speaking against the employer without permission. So therefore, they found that they had not actually breached any of those sections that I just mentioned. So what's interesting about these cases is, although there may not be a direct correlation with using social media to express a political opinion, they do involve individuals who have express their public opinion or have their employers perceive they have a public opinion about a political issue. And this has been their basis for grounds of termination. So it brings an interesting question, which is if you have or are perceived to have a political bias that is contrary to the stance of your employer, is that a problem and can you be terminated? And then with social media now being more and more present and a tool for expressing opinion, this means that we'll continue to see more cases where individuals have adverse action taken against them for expressing their views. So I guess the biggest learning from these cases is, what is the court stance? How do they view the connection between expressing your political opinion and the employment itself? And then Lattouf is probably the most landmark case we've had in terms of social media in the workplace, as it delves into the purpose of Section 772 of the Fair Work Act, and looks at both holding a political opinion and then actually expressing that political opinion on social media.
Yeah. So now expanding on that, what do you think this means for employers with Lattouf's decision, especially when it comes to what's the boundary and what can employees do outside the workplace and what can't they do?
Yeah, so I think I'd say it's pretty significant. Like you mentioned, it is a landmark case, and the court found that political opinion has a broader ambit than it honestly previously did. Most employment contracts and social media policies talk about not bringing the company into disrepute, but this decision obviously challenges how far those clauses can go and how much control employers can have on employees outside of the workspace.
Yeah, so I guess the question of whether someone can be fired for what they do outside the workplace isn't new. But I think the main thing here is of what makes it a new kind of landscape is with social media and the rise of social media, it makes it way complex. The risk that employees' conduct will damage a business and the reputation is no longer just confined to where they physically are, because it's broadened now to what they do on their phone, social media, what they post. And it can really just have really big impact on everything. So there's a wide array of things to consider.
Yeah. And I think Lattouf also sends a clear message that employers have reached the limits of acceptable interference into employees' personal lives. And I don't think it's enough. It's no longer enough for employees to rely on breaches of policies to govern employees or out of hours activity. I think the courts have placed a lot more emphasis on them having to justify dismissal for conduct deemed by the employee to be potentially reputationally damaging.
Yeah, and so The judge also in this case emphasized that the law doesn't just protect political opinions that people hold, but it's also how they express those opinions, right? So when you think of it in terms of social media, this makes it more challenging for employers because how are they going to justify dismissal for expression of political opinions? But how do you do that when these opinions can be unpopular or controversial? And it's kind of like that fine line of how they know how to navigate that.
Yeah, and I feel like there's like a new set of questions that the courts are going to have to like consider now. Like, was this direction to the employee lawful and reasonable? Was the post actually damaging? Was the employee being targeted because of their opinion, or did they break a legitimate rule? I think it makes it even trickier for employers because even if they give a different reason for firing someone, the court can look behind that and still determine that they fired someone because of their political opinion. And in this situation, if the court accepted that Lattouf was told not to post about Israel or Gaza, ABC would have had to still prove that the direction was lawful and reasonable, which is a difficult hurdle.
Yeah. And as you said, Andrea, so the lawfulness and reasonableness of these directions, that's something that's going to be scrutinized by the courts and like them looking into how that comes into place. And when it comes to employers, I guess this case is just a wake-up call for the factors to look into: the nature of the business, you know, how senior these employees are, right? The broader social context and what's happening around the workplace, and like managing reputation of a company. And these things are so important, while also balancing how does an employer respect an employee's views, especially now in this age where, you know, people want to be able to give employees a workplace where they can be themselves and express their views. But then, you know, how can employees do it in a way where it's not compromising the employee's position? So I guess that's something which we still don't know. You know, it's just a new area right now because this Lattouf case is also, that's why it's big, right? Because we haven't had that many situations where we've had a social media related dismissal for political opinion. And so yeah, in terms of the key takeaway from this decision, in terms of its implications, what do you think are the social media implications for the workplace now?
Yeah, I think you guys explained it really well. Like it's such a tricky landscape to navigate. And I think there's a lot of implications for employers moving forward to make sure that they don't wrongfully terminate someone because as we've seen, the courts are very willing to look behind the smoke and mirrors and see why they actually got terminated. So I think for employers, the implications right now is they do need to be aware of the Fair Work Act and how they can't take adverse action against their employees for holding or expressing their political opinions. They also, I think, need to do a thorough review of their social media policy to see what's actually in it. Are those policies lawful? Do they discriminate against employees in a certain way? They need to look holistically at those policies.
And they also need to communicate it to the employee and make sure that they're aware of it.
Yeah, it's a two-way street.
Yeah,
exactly. And then also just the policies do need to be clear and consistent across the board and like clearly define what constitutes a breach. And I think, like you said, like training on what are the expectations of employees using social media and extending that beyond just in the workplace, but also outside of the workplace. I think also we've kind of seen now the importance of social media policies because especially in public facing roles or client facing roles where there are going to be a lot of differing opinions, and does your social media impact the business itself? And does it damage their brand? I think that's a big thing. So I think it really requires a more nuanced and detailed approach to drafting policies for employees while also simultaneously balancing their legal obligations. So I think this has been a very huge landmark historical case because we now are in the age where everyone has social media. You are likely friends with your co-workers on social media.
Yeah, that's true.
So the implications now don't end between your 9 to 5.
Yeah.
They extend far beyond. And it's going to be very tricky, but I think Lattouf has really laid a good foundation for employers to wake up and go, we need to look at our social media policies and see what's appropriate, what's not. And then if they do make determinations, to figure out whether they're lawful or are they going to have a claim brought against them, which could damage their reputation even further, like the ABC. So very interesting topic. Thank you both for looking into it. And see you on the next one.